Good morning. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for November 9th, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, I'm going to say what you call our first case, but Mr. Sacelo, what are you doing here? Why are you throwing me off?
Because, Judge, I thought it was on the expunction. I wasn't sure who was going to be covering that, the county attorney or office. So
Myrna, I have them both being agreed. Is that right?
Yes, ma'am. I checked them this morning.
Okay. I think we had them taken care of, Javier. I just didn't want, I know you're busy, so.
yes, ma'am. Thank you so much, Judge. Can I be excused?
Absolutely. Take care. All right, let's call our first case, please.
In cause number 2022, DCV 2486, Terry Finklia versus Pay and Save et al. Announcement of council, please.
Good morning, Your Honor. Daniela Labinalti for the plaintiff.
Your Honor, Hugh Lyle for the defendant, Pay and Save Inc.
Good morning. And so I have this scheduled for both the special exception hearing and summary judgment hearing. Certainly I received the pleadings. What I didn't see was scheduled, but was included in, I believe, plaintiff's response was a motion for continuance. So I don't know that that got independently scheduled as it was part of the response. But Ms. Labinati?
It's part of the response, Your Honor. I mean, I still answer just subject to that. But I mean, my whole purpose of we're being here, we just filed the lawsuit. We got an answer, a third-party designation. We immediately amended to add the third-party designation. The third-party designation was just recently served November 1st. We have not received an answer from them. My client was an invitee on their store. They're saying we don't own that piece of that area, even though their business in there. But I mean, I understand how businesses work. Some people lease, some people own. We understand that they're claiming that the other company is the responsible party. It's too early, Judge. I need to have an answer from them because I've had it both ways. And I mean, getting to the meat of this, I have had it to the opposite, where they have claimed designation third responsible party, the company that occupies the premise. So we need to have depositions in this case to find out, who they claim is responsible. I need to know who is responsible for maintaining, who is responsible for inspecting. It's not just ownership and title. It's a matter of control and duty to inspect, duty to repair. There's no question my client went as an invitee, as a customer at Food King's store. And the incident happened in their store. They say that area, it's not theirs, but this is very premature. And maybe after discovery, I will agree to dismiss it. But I think the Court of Appeals, and this is something that Judge Alvarez had taught me many years ago, the law is very clear. If I request the continuance because I need more discovery, I think the law is black and white on the issue. And I was hoping that after my response, we would not even have this hearing and, we would not waste the court's resources, but I still filed an answer subject to my motion to continue. But we don't even have an answer on the right party, Judge, that they claim is the right party. So I don't know, because they might come in and say, yeah, we're on paper, we don't have the title, but they're responsible for, maintaining this, or we told them to repair it. We don't know, Judge. This is too premature.
And I apologize, I misrepresented because you did have a separate motion for continuance filed on the 17th of October, but I think there was also one for the November 9th hearing that was part of the response. So
right.
The fact that we did not get that scheduled independently, although I know Mr. Lyle, I believe you responded to the motion for continuance as well, at least the one that was in the plaintiff's response. So you have a position on that?
Imagine that.
Mm-hmm.
Yes, ma'am. There's several things working here. We've got a continuance, my motion for continuance. We have special exceptions, and then we have the motion for summary judgment.
Mm-hmm.
The motion for continuance fails because it's not verified. Okay, there is no verification. There is no verified motion for continuance. When the continuance is on the motion for summary judgment. It's not automatic. It is within the court's discretion. However, the Supreme Court, as we pointed out in our reply, sets forth three things that must be taken into consideration. The first two, not any question they comply with, but the last thing is, and that is, what is it that they have to verify by affidavit or verified pleading, what they have done in order to rectify the problem. And in this particular case, I mean, counsel just admitted to it. We've got, and so the court kind of understands what we're talking about here. This is, I represent Pay and Save, and they operate the Lowe's and the big, Food Kings. We've got a Food King over there on Dyer. It is in a shopping center. And in that shopping center, we rent the inside of that building. The owners of and it's in our affidavit, in our motion for summary judgment, the owners of the real estate retained the right to control, maintain, and inspect all of the common areas, including the parking lot. So in this particular case, and we pointed this out in our response, what could have happened is that once it was divulged by our answer and our motion to designate responsible third parties, once it was disclosed that the true people who are maintaining and have ownership and control over the parking lot are the people who were designated as responsible third parties and now have been sued by the plaintiff. Okay, those parties are the most motivated to provide affidavit testimony, affidavit evidence that in fact somehow casts a question on our summary judgment evidence. What we don't see here is any attempt, any evidence of an attempt by the plaintiffs to obtain that sort of evidence to refute the motion for summary judgment. And, you know, whether we like it or not, the very first sentence of Rule 166AB says that a traditional motion for summary judgment may be filed at any time. That's what we did. Plaintiffs and our affidavits, we believe, negate an essential element of this premises liability claim, number one. And two, the plaintiffs have not shown by argument or certainly by not any sort of summary judgment proof. Not only was the motion for continuance not verified, but the response to the traditional motion for summary judgment had no summary judgment evidence casting any sort of doubt as to the summary judgment evidence which we provided, which is the affidavit, which clearly sets forth that by deeds and leases and the testimony, the affidavit testimony from Pay and Save, that this particular incident, even as described in the plaintiff's pleadings, occurred in a crack in the parking lot. So, number one, the motion for continuance it fails because it's not verified. Two, the response to the motion for summary judgment, which or the motion for summary judgment was timely filed, and the response fails to negate or to create a fact question with regard to an essential element of plaintiff's claims with regard to the premises liability claim. And because of that, summary judgment is proper as far as this defendant's concerned, and the case can go forward against the owner of the real estate who had, without any question, based upon the summary judgment evidence, the right to inspect, control, and maintain these common areas. So we believe the motion for summary or the motion for continuance should be denied, and that the motion for summary judgment should be granted.
Your Honor, I can make this easy for everyone because this is very disingenuous. Apparently, the verification wasn't attached. If I may ask the court, to reset this for 7 days so I can file the verification today in the affidavit? Because clearly, I'm asking the court, Mr. Lyle, you're now the judge. Clearly, we have listed all the things that have happened to address the issue. We have addressed the need for deposition. We have amended the petition, and that's on the record, Judge. It's part of the file. It's part of the record. We have issued the citation on the correct defendant, which were just served of November 1st. So if he's playing on this technicality that I forgot to attach my verification, I will file the verification right now, Your Honor, and we can have this done via submission, and the court can take this into consideration. I think the law is very clear, especially the Court of El Paso Court of Appeals, on the issue of motion to continuance of need of discovery. And I cannot file a response when I just filed the lawsuit and I have not taken any deposition of the employees on the issue of control. It's undisputed that based on the file on the record, that the incident happened to their location, to their store, a store that they lease. My client was an invitee. That's not disputed. My client was injured on their premises. They say they do not own or control that, and a third party does, and they properly filed a designation of third responsible party. I have done no discovery, no written discovery, no disclosures. I have no idea if that's what they're saying is accurate. Just because they say it's part of the lease, I don't know. I need to take the depositions of the right party, or at least have the attorney respond on the correct party and get information on the issue of documents, leases, and all that information that they attach in the motion for summary judgment. So to make this proper, so there is no errors, if the court would allow me to attach my verification, I'll file it today, Your Honor. I didn't realize that it wasn't attached. That's inadvertent on my part. My apologies. Initially, we were hoping this would, anyway, go away. But I apologize, Judge. That is inadvertent on my end.
Okay. Mr. Lyle?
Yes,
I just saw you shake your head when I heard Ms. Labinati ask for, I guess, some leave to amend. I'm assuming you're not in agreement there, and if you have something else, I'm happy.
Yeah, and I apologize to the court, Ms. Labinati. I was not attempting to usurp the court's authority by shaking my head. I did it unconsciously, made that shake of my head simply because there are rules, and there's 21-day notice rules. There are 7 days prior to the hearing date in which to file the responsive, and it's not, oh, we made a mistake and therefore we get a do-over. It's just not, that's just not the rules. But having said that, whatever the court's pleasure is, I believe that everything was done properly. There's been, even if it was verified, quite frankly, Your Honor, even if it was verified, there's nothing within the motion for continuance that shows what sort of due diligence was used in order to counter if the affidavit, or if it had said we had made 15 phone calls to the owners of the real estate in order to obtain an affidavit that, in fact, that we believe that Pay and Save had exercised or had assumed the responsibilities, okay, something along those lines, where that they had actually tried to get summary judgment evidence before the court. But there's none of that. There is, even if it's verified, it still fails because of a lack of a showing of due diligence on the part of the plaintiffs.
But in that sense, Mr. Lyle, are the entities or individuals that you're referring to, for example, that plaintiffs should have approached, are these some of the newer parties in the lawsuit? Those are
the companies that leased the property, or the building, the entire side of the building that we operate in. And counsel, is fast and loose a little bit with some of the terms, but the truth of the matter is that the inside of that store is what is leased, and outside of that store is what is owned by the people who were identified in response to, by the responsible third parties, and who have now been made parties.
Understood. All right. So it is a little tricky, and I guess my apologies to council for not addressing the motion for continuance sooner. It kind of all got lumped in together for today's hearing, which scheduling wise is not the best. But I am going to entertain the amendment to the motion for continuance to review. So Ms. Labinati, if you can get that to the court actually today,
Yes,
an
Judge.
amended motion for continuance, I will review that. Of course, that is anticipating that after I review it, I don't know, Mr. Lyle, if you're going to have anything in addition to what I've heard today, but I will rule on that. It's kind of strange because it's a delay anyway. What I mean to tell you by that is if we have some issues, again, with the amended motion, Mr. Lyle, the court is happy to consider a further response on that. But the court is also time limited in terms of how to schedule this, just with some upcoming holidays and then some dates when I'm going to be out right before the holidays. So before I go ahead, Mr. Lyle, you look like you want to say something.
And it was my understanding that what plaintiff had requested was to attach the verification and not another attempt to amend and provide additional responsiveness other than a verification.
That's what I understand. Mhm.
Okay.
Yes, Your Honor. So for the motion continue to be valid and for the court to rule accordingly, I need to have a verification that discovery is necessary on my need for continuance. So it's listed in the motion. We have done all these things despite what counsel says we haven't. I mean, if we can do work by calling defendants, judge, I don't know why I have all those employees and I'm paying all those bills, because unless you file a lawsuit, I don't get any answer. I don't even get an insurance adjuster to tell me what the insurance, limits are. So we have done everything we can do, which is bringing them in the lawsuits, having attorneys file an answer, request disclosure. So I'm just going to enter that into, it's either a verification or it's an affidavit. It's the same thing. So I will do that and attach it and submit it to the court and e-file it just so that we have proper record for the court. And so I will make that a correction, Your Honor, today, and I will attach an affidavit in support of my motion to continuance that lists all these things that are in the motion to make sure that it is absolutely accurate. And again, Mr. Lyle is shaking his head. Mr. Lyle, you know the rules very well. You can either have an affidavit or a verification. I can choose to do either. So I am going to choose the affidavit so that, you don't have any doubts of what I did or what I didn't do. So with that, Your Honor, I thank you, Judge. That's the only thing we need. I don't think we need to have a hearing on this unless Mr. Lyle needs one. I'm okay for the court to rule on this issue via submission. My dad passed, so I'll be going to Albania on Friday. And so I will be also gone for a week or two, and with everything else going on. So I don't have time. If I can avoid the hearing, I would appreciate it, Judge.
So I guess there's a couple of things then that we're talking, and I'm shuffling a bunch of different things here, but in terms of the motions, because I'll say now motions for continuance, these were only with respect to the summary judgment, correct? The special exceptions are still outstanding for today.
Yes.
Yes, Judge. We filed a response, but yes, the special exceptions are still pending. But if Mr. Lyle feels like he's going to prevail on summary judgment, Your Honor, I don't know if he wants to waste the time on special exception. But either way, Judge, I've amended my petition to address the special exception, and I'm ready to address it.
Mr. Lyle, have you had a chance to review it?
Yes, I have. And first, what I'd like to respond, if I could, to counsel's comment. A few moments ago, once I pointed out the fact that the motion for continuance was not verified, counsel represented to the court that they simply had not attached the verification to it. Okay. Now, I understand that that's what the court was going to grant her leave to do, was to attach that. Now, what I'm hearing is she's wanting to bolster her claims, which is a completely new animal with regard to contents of an affidavit. And I don't believe that's appropriate, Your Honor, but and we don't believe that it's necessarily called for at this time. As far as and with regard to verification, simple verification of the motion for continuance, I understand the court's ruling to be that. With regard to the special exceptions, counsel has made an attempt to cure a lot of them, because this is it's a pure and simple premises liability case. Okay. And because of that, as the court's well aware, it's a special animal under Texas law in that once you can either have a premises case or you can have an active negligence case, but you can't have both. Okay. And in this particular case, what she's pled is premises liability. And then she goes further claiming ordinary negligence. And she continues to allege failure to negligent training, negligent supervision, is what we've included in our special exceptions. Those allegations and contentions of ordinary active negligence in a premises liability case are inappropriate. And that's the basis for our special exceptions, Your Honor.
Okay. So it sounds like that's still outstanding. All right. I'm seeing the last amended petition I'm seeing is from October 18th. All right, there's not anything else. There isn't anything newer than that. Okay. All right, Ms. Labinati, let's look at these. Your response to Mr. Lyle.
Yes, Your Honor. A special exception, unlike Mr. Lyle represented to the court, is not a motion for summary judgment. Special exception is, the purpose of special exception is to give defendant notice on all the viable claims. We have given the defendant all the notice required under the law in terms of the fair notice. We did correct on our amendment to make it clear that this is a premise liability case. This is not a negligence case. However, unlike Mr. Lyle says, that's not the law when it comes to premise liability case. The premise liability case still requires the plaintiff to show that the defendant was negligent or not negligent in their ordinary care in providing inspection of the area and fair notice to the plaintiff, in keeping and maintaining the premise in a non-dangerous condition for their invitees. That's part of the question. And the pattern jury charge asks whether the owner of the premise exercised reasonable care and is an ordinary prudent person. So still the standard is the same. We're not submitting a negligent activity claim. We're still submitting a premise liability claim. We just added extra facts. They're just language facts in terms of the employees of the store, what they should have done or would have done. I've tried several premise liability cases. In fact, with Mr. Lyle himself, one. And that's really the questions you ask employees all the time. So it's not that the facts, Your Honor, and the word negligence changes the claim from premise to negligent activity. I do not have a negligent activity claim. If he wants me to make sure that it's part of the same premise liability, I can put it in the same language, but I am not making a cause of action for negligence. The cause of action is still premise liability claim, but the language to be used is still the same. Did you exercise reasonable care? Were you negligent in inspecting? Were you negligent in maintaining? Were you negligent on repairing? Were you negligent when you received notice that there was a dangerous condition? That's still the question for the jury, whether it is a premise liability, whether it is a negligent activity. The difference between a negligent activity and a premise liability is that it's obviously a better standard for the plaintiff on a negligent activity. And the question is not whether the owner knew or should have known, and the duty to make safe. In a negligence case, is a simple, did the owner exercise reasonable care? So it's just a different standard when it comes to the negligent activity case. And I have made it very clear in my amendment that I'm not making a claim for negligent activity. And a special exception, it's a matter of him clarifying claims or addressing claims that are not viable. I have removed the claim of negligent activity, Your Honor, and I believe that's very, very clear. I'm not sure why he's so confused with that. Especially in the amendment, Your Honor.
Your Honor,
Anything else? Yeah, Mr. Lau, go ahead.
page 3 of our special exceptions, what we specifically pointed out, and in contrast to what counsel is telling us, is that in her second amended original petition, at paragraph 5, she pleads that the defendant was negligent in the training and supervision, which is an active negligence claim. She further, in paragraph 5, pleads that we were negligent in hiring, which again is an activity. Then in paragraph 5, she goes further. She pleads, quote, general negligence. Okay. And counsel's correct. I mean, and we have had cases together, but the question is, was there an unreasonably dangerous condition? And was it something that the defendant knew or in the exercise of ordinary care should have known about? And that it was then will approximately cause the plaintiff's injuries or damages. This allegation of negligent hiring is not something that's submitted to the jury. Now, it may be that they negligent hired somebody and then therefore they didn't know about something, but the negligent hiring is not the active negligence cause of action, which is proper in a premises liability case. Because of that, we especially accepted, and I believe she did try to cut out a number of them, but in the second amended petition, it still is included in there. That's why we brought it to the court's attention.
I will remove, Your Honor, so that portion as a separate claim, so it's not, so there's no concerns about that. So I guess what he's referring to page 5. Actually, it's page 6. I will remove the page 6 claim paragraph, so there is no question about that because it's already included in page 4 and 5, and I'll just remove the what's the word? Failing to properly train and supervise. I don't think it's needed because Texas is fair notice, so I can try my case on those issues and still. So somehow he doesn't think I'm bringing that claim. I'll make it easy for the court. I'll cut it short.
Mr. Lyle, was there some other area? I'm not sure if that's going to resolve everything.
It's paragraph 5, Your Honor, of the second amended original petition. If paragraph 5 was redacted or removed, I believe that would probably cure our concerns.
So what I will do is await, I guess, an additional amendment by plaintiffs on that matter and see, Ms. Labinati, if it's something that you can accomplish fairly quickly, meaning by the end of this week, then Mr. Lyle, if you had an additional concern, I would probably give you another week to file a response with the court and anticipate having, if something is still outstanding, reconvening on December 7th at 10 a.m. If there's anything still outstanding. Okay, so.
What I would do, Your Honor, is if Ms. Labinati is going to amend, once she amends, if I have an issue with it, I'll contact her and we can discuss it. And if we need to get the court back involved, we will. But I trust that if she's going to amend, that's exactly what she'll do. And if there's a problem with it, we'll visit together.
Right. And Mr. Lyer, if you want to highlight, like send me an email, just tell me exactly highlight so I don't make a mistake on, because I don't see a number paragraph. I'm looking at the page. I understand what your concern is, so, and I will address it, but just so I don't, so we're on the same page, go ahead and highlight it on my amendment pleading. I've had an attorney do that, and that's easier so I don't miss something and we don't waste the court's time again.
I'll get it over to you, Danielle.
Okay, thank you.
I still want to keep that date. And is that, and let me tell you why, because let me backtrack before I move on, because I'm getting ready to move on to something else. is, for my purposes, summary judgment, well, I'm awaiting something from Ms. Labinati on the motion for continuance. We'll have the special exceptions somewhat outstanding. What I do not see here is that we've ever entered a scheduling order for this case. And so to the extent that I could use this as a scheduling status conference, I would like to do that too. And the reason I bring it up is because then I would utilize the December 7th date for entry of the scheduling order.
That's fine, Your Honor. I'm hoping they will file an answer. The citations are out. They were served, so hopefully we'll have an answer to make sure we have all the attorneys. The defendant were served November 1st, 2022. So hopefully we'll get an answer by Thanksgiving.
I will push that back then, that December 7th date to December 14th.
Right.
I know it's not a lot more time, but it should be just a little, it might 7th will probably be way too close.
Yeah, and
So-
I'll make sure the defense attorney, whoever that is, has notice of that, because I know that sometimes that happens where they file an answer and there is a hearing and they didn't get notice. So I'll make sure of that, Judge.
You know what I'm thinking is that rather than have that be the entry, we'll just use that as the scheduling status conference.
Okay.
Yeah, rather than go there. It shouldn't put us too far back in terms of where we can secure a trial date. We'll still be in good shape. Mr. Lyle, as I mentioned, with respect to the motion, what will be the amended motion for continuance, I guess, or whatever we want to call it with respect to the verification. I don't want to close you out if there was something additional once I receive it. Once you receive it, if you have some type of response or objection that you want to put in written form before I rule, please do so. I know it's kind of weird. It's kind of cart before the horse, or however you want to horse.
I understand the council is going to present that to the court today, and we'll have something by tomorrow. I can get you a response.
That's great. Okay. So for now, we have a few things outstanding, but we will reconvene on December 14th. And then just go from there.
All right.
Okay.
Thank you, Your Honor.
Thank you, Mr. Lyle. Thank you, Ms. Labinati.
Thank you, Judge.
Thank you, Judge.
Okay, who's next?
The second one on page 2, Judge.
Oh.
In cause number 2021 DCV 1109, Eduardo Alfonso Villa versus Francisco Arambula Nunez et al. Announcement of council, please.
Cindy Vasquez on behalf of defendants of One Oak Inc. and Andrew Gomez, Your Honor.
And I'm Josh Ham on behalf of defendant Mr. Nunez and Flores Logistics.
So we're missing some folks, no?
Yes, I believe we're missing plaintiff's counsel, Your Honor.
I have it down as Lauren Esparza. Was it? I feel like it was someone else, but maybe I'm wrong. So maybe we can come back to this one. Who are we missing?
It's either Lauren Esparza or Piero Garcia or Carlos Leon.
Okay, I think I remember Mr. Garcia. Okay, so Mr. Marufo, we need to track them down. We'll
Yes,
come back to that case and we can go to the next one.
Okay, staying on page 2, Judge. In cause number 2022 DCV 2702, Fred Hurd Heiser versus PPI and Towing Services LLC et al. Announcement of council, please.
Good morning, Your Honor. Michael Hirsch for the plaintiff. And Mr. Ellis is on mute.
Mr. Ellis, you're muted. If you'll unmute, please.
David Ellis on behalf of the defendant. Ready, Your Honor.
Good morning, gentlemen. We were scheduled for a default hearing. Motion for default was filed on October 17th. I see an answer filed on the 25th. So I don't see anything else. What's going on?
We've settled the case.
Is that right, Mr. Hirsch?
Judge, I'm pretty sure we've got it done. Just need to iron out the details.
I have the money in my trust account already, so.
So how much time?
That's the main detail.
That's pretty good. How quickly are we going to close things out? Can we do it in 30 days?
Probably within 10. I plan to be in Tyler by about the 23rd, so
So that means yes. So I'm gonna, let's see, just set this for status on December 14th. If you all have it squared away, send me documents dismissing, whatever you want to do, non-suiting, however you want to do it before
okay,
then.
Your Honor.
All righty, December
Thank you very
14th at
much.
10 a.m. Take care, guys.
And you have a good day.
You too.
Bye-bye.
Who's next?
Thank you.
Thank you.
Top of page 3, Judge. In cause number 2020 DCV 2256, Christopher Hines versus Jesus Mesa et al. Announcement of council, please.
Yes, Rachel Hatton Adams, counsel for plaintiff.
Good morning, Your Honor. Dave Larson for defendants.
Hi, counsel. So we're here for entry of scheduling order. And my recollection was we had some, not in a bad way, misunderstanding, but we were not all on the same page necessarily. Well, you all were not. It had to do with the experts, right? The experts deadline on the scheduling order. I remembered it. I think you all, someone had called the court a couple of weeks back, and I went through my Zoom recordings. I checked with court reporter on the hearings. I didn't find anything. Okay. And so I don't say that like it didn't happen, because I feel like we had that discussion. And so I really, when you all called, went through and checked everything that I could check, you know, record and unofficial record, and I didn't see anything. So Mr. Larson, do you have anything more? Do you have something that I don't have that would tell me, you know, like I had nothing that reflected an agreement. That's for sure.
Oh, certainly. Well, I mean, when you say agreement, Your Honor, I think of an agreement be between counsel, but we didn't reach any kind of agreement in that way. There wasn't a dispute either. This is my recollection, Your Honor. This is many months ago, before plaintiff's counsel was on leave. So my recollection was, and I could be wrong on I think I mentioned this last time, I could be wrong on the hearing date, but it made sense that it would have been our last hearing, I think in May or June.
Right.
So, you know, that's my recollection, is that we had, you know, it was at the end of the hearing, I remember bringing it up. And by the way, Your Honor, something along the lines of, we're not reopening experts, something to that effect. I honestly don't remember the words, Your Honor, but I remember bringing it up because I remember it was an important issue to us. And so I don't know if it wouldn't be caught on Zoom, or I'm not sure.
And that was my concern, because I feel I also remembered a conversation. I just don't recall the details, which is why I asked my court reporter to go back for the hearing. I went on to Zoom, which even if we weren't on the record and we had mentioned it off the record, Zoom probably should have caught, Zoom, YouTube, I keep saying Zoom, but not YouTube. YouTube, it's always like kind of my fail safe for stuff that, you know, I go back and look at. I went through, it was the May 11th. Actually, I went through, I think even as far back as February, but I know it wouldn't have been in February or early 2022. But I went back and I went and I listened and I looked for every time that we were here, and I didn't see that where there was some agreement to have stuck with the date, the previous deadline. And so unfortunately, starting now, I guess, having the new scheduling order, my thought is we're going to go with the new deadline. And Mr. Larson, it was something that had I verified that, you know, then I may have gone there, but I don't really know that I'm not sure why we would be doing that. Why would we be sticking with that old deadline, since we basically kind of kickstarted this case, even though I know we've gone through a lot. So with that said, the new deadline, I don't think I've seen the draft of the scheduling order, but that, if you all are not going to agree to it, that's going to be my call. So Ms. Hatton, I don't know if you all have circulated a scheduling order. Mr. Larson, I definitely will note your objection with respect to the expert deadline, but that's what the court's order is going to be, okay?
Sure. Your Honor, can I just ask, is it just on YouTube? Is it something that I could search myself just for my own edification, I guess?
Sure, I try to leave just about every video for that reason, right? I have us down for May 11th is when we had that status conference. And we did we did have our hearing is on there. Our hearing is on there. That conversation is not. And I honestly started just racking my brain thinking, did we come back at another time where maybe you all popped on a Wednesday docket and we had a conversation, but I don't recall anything other than the scheduled hearings that we had.
Yeah,
So,
I don't recall that either, Your Honor. How would I find it if I just search?
If you go to the EP County website and you look up courts and you look up the 210th, the link to the YouTube channel is there. You know, it's a funky thing that if you click it, you know, you're good. And then from there, it'll be by date. So you'll see there's a ton of videos on there.
Okay.
Okay.
That's good.
All righty.
All right.
So if you all will please, if you haven't already, I haven't seen it yet, send me the scheduling order so we can get that entered. And then I think we have our dates. If we need dates outside of then, Mr. Larson, certainly, if you find something I didn't find, let me know.
Okay.
Okay.
All right.
Okay, guys. Thank you.
Thank
Is there
you.
anything else?
I believe that's it.
Okay. Carry on.
Thank you.
All right. Who's next?
Bottom of page 4, Judge.
Mhm.
In cause number 2022 DCV 0709, Andrew Martin Squire et al. Versus unknown heirs diversities et al. Announcement of council, please.
Your Honor, David Lutz for the plaintiffs.
Good morning, Judge. Jessica Mendez, appointed attorney ad litem.
Okay, good morning. Let me see. I'm just receiving now the report, the ad litem report. Ms. Mendez, you want to give me a quick rundown? I know we discussed some things, but I had asked for the report, so let's see.
Yes, ma'am. Yes, ma'am. Mr. Lutz represents the children, the children of 2 deceased individuals, and I'm going to try my best. The unknown heirs that I was appointed to represent are the unknown heirs of Mary Rose Squire. Mary initially married Max, and during that time of marriage, they had one child, one son, Your Honor. But during that time of marriage, they also acquired an interest in a real property that is an issue here, the real property here being in El Paso County, and identified it in my report. When they divorced, Judge, Max was to receive the interest in the real property, but unfortunately, that did not happen. There was a lapse in oversight, so that interest did not transfer over to Max during the divorce. Excuse me, Judge, I'm feeling a little under the weather.
I'm sorry.
And so subsequent to the divorce, Mary went on her way, Max went on his way, but Max remarried. Max then remarried an individual by the name of Martha Squire. And during that marriage, 2 children were born out of the marriage, and the 2 children are plaintiffs in this particular case. Both Andrew and Susan are plaintiffs in this case, so they are descendants or children of Max and Martha. Max subsequently died. He died back in 2003. Martha was appointed executor of his estate, and as an executor has the authority to transfer property in the real property. So she did that. She transferred all those properties. But she subsequently has died as well, Judge. She died October of 2022. And the only heirs that Martha has at the time of her death would have been her children, both Andrew and Susan. But my role in this particular case was to find out if there was any unknown heirs of Mary, which would have been the first wife, due to the fact that there is an oversight in the transfer of the real property. The child that was born in that marriage subsequently has died, and at the time of his death, he had no surviving wife or no surviving children. So the interest would have transferred to the parents, and at that point, it would have been the father. His mother, Mary, died prior to the son. So when the son died, he had his heir would have been the father, because he wasn't married, didn't have any children. So it goes up to the parents, and he had a husband that was still living. I researched the state that was filed here in El Paso County for Max, the husband and the father, and everything that was presented in the petition was confirmed as through the probate case. The probate case was very detailed on who his marriage is, how many children he had, and so forth. While I could not find an obituary for Mary, the plaintiffs did attach her death certificate as part of the pleadings, and the death certificate does identify, it's pretty apparent to me that she never remarried, Judge, because her name was the exact same married name that she had before, and it identifies her as divorced. And it does not name a surviving spouse in that death certificate. So based on that, based on doing some research on the internet, I don't believe that Mary, which is the first wife in this particular case, has any unknown heirs that potentially can have any interest in this real property, which is what is before the court to resolve.
Mr. Lutz, why is this not filed in the probate court, where I guess some proceedings had taken place?
I think just more that I'm a civil attorney and I just wanted to do a civil quiet title based on what Texas Title Company had presented to us, just to clear up the property record.
And just to add to that, Judge, I think plaintiffs filed their petition prior to the second wife, Martha, passing away. She just
right. Yeah, that's just here in October, right?
Right. And they had a transfer on death deed for that. So I don't believe they'd require a probate for the mother that just recently passed away.
Wow. Well, Ms. Mendez, thank you for all of that information. That's
and the issue would have been the first wife, Judge. The first wife is the one where if she had any unknown heirs, and just from the fact that her death certificate said she was divorced and doesn't look like she was remarried. Had she been remarried, then I think that would have caused some concern to the court and to myself as well. But I believe I'm pretty satisfied that she did not remarry after her divorce.
all right. So let me look then at the. Do we have some type of proposed order, Mr. I'm sorry, is it Lutz or Lutz?
Lutz. And okay. I emailed a proposed stipulated order a couple of weeks ago. I'm happy to resend it.
Let me see if I can find it. If we have it here sometimes my search skills are fruitful. Let's see, a couple weeks ago.
I believe I sent
final judgment. There it is.
On the 26th, yes, of last month.
26th. Miss Mendez, did you review I thought we had at the last hearing, you had reviewed the final judgment as well?
Yes, that's correct, Judge. I should have my electronic approval on that order.
Yes, okay. Okay, let me give this a quick review. I don't anticipate having any issues with it. If I don't, there will be a signed stipulated judgment quieting title in the documents of the court, Mr. Lutz. If not, you'll hear back from us. Okay.
Thank you, Your Honor.
Send this, whatever you need to do to close things out, please just send it on over. Okay.
Yes, Judge. We also sent an order on my fees that Mr. Lutz.
Oh, let me see. Let me see. I have a couple of emails here. Let me see. I just opened the one that was report of the ad litem. There it is. Order approving attorney ad litem fees. My apologies. Okie doke. I will go ahead and sign that order as well. Alrighty, folks. Thank you very much for all of your work on this one. Mr. Lutz, take care. Alrighty.
Ms. Mendez. Appreciate it.
Bye.
Bye.
Okay. Who's next?
Going back to page 2, Judge.
Mhm.
In cause number 2021, DCV 1109, Eduardo Alfonso Villa versus Francisco Arambula Nunez et al. Announcement of council, please.
Good morning, Your Honor. Piero Garcia for the plaintiff, and my apologies for being tardy. My staff had it on the calendar for tomorrow and not today, so I saw Mr. Marufo's emailed and logged right in.
Okay, thank you very much. So I feel like, okay, well, we had announcements. I don't know if we had announcements earlier. Did we have announcements already? Sorry, I'm doing two things at once here.
We did, Judge.
Okay, so I thought you all are ready to go to trial. That's what I remember.
We were, there is some additional discovery that we've requested, really just deposition of corporate reps from two of the defendants, Your Honor. So we're working on scheduling that, but we are working off of the scheduling order that we had filed with the court recently to get that discovery done and then be ready for trial. I think we have an initial trial in January and then a backup date in April.
Okay, let me go back and look at that. Okay, so our discovery control plan entered in September. All right, let me just make sure. All right, so we have that for January 20th. Are we going to make that January 20th date?
I think, Your Honor, one of the defense counsel had a potential conflict, which is why we had a backup date. So I don't know.
So I don't have one actually scheduled. Mr. Ham, that's the one where we were trying to get you squared away, right? And there was just, we couldn't get past that. Okay, so, but our discovery, okay. So I have a notation here, discuss backup trial date 4/5 and 4/7, April 5th. For the docket call, so April 7th trial date. Mr. Hernandez, is that still a good date? If we had to specially set them? Let me look. Is that what you all kind of understood in terms of a backup date?
Yes, Your Honor.
So everybody has already cleared all their calendars and ready to, all right, let me go over there. It's good.
Judge, on the 7th, it's a Good Friday.
That's the problem with that date. I couldn't think of why that was resonating with me. April 7th.
I believe, Judge, you were trying to move them to the 14th.
Okay, but do we already have, okay, so yeah, Good Friday is a holiday. So that's a problem. Let's look to the 14th of April. But God, did we already fill that one up, Myrna? I thought we had.
That is the backup trial for Martel, Judge.
And we didn't put anybody else on there? Let me see. We have the Martels. Yeah. We have the Martels. Let me look at this list. I feel like we had, yeah, I feel like we had already put somebody on here. Let me go through them. It's the Ford Motor Company case. That one needs to be specially set. A 2020 DCV 3335.
Yes, ma'am.
That one needs to be specially set. That is the one that looks to be going. So that means we need a new backup date, guys.
We'll take the earliest one, Judge.
Yeah. How are we looking? How are we looking? Let me get back. Yeah, and the thing, we ran through some of these scheduling issues with other cases because the Friday before that is also a holiday. And then if we go further back, then my schedule gets full with specially set cases. So yeah, so March 24th. Nope, can't do that. That one has to go. So if I go backwards, I'm just going through here. How long more or less do you all think this case might take?
Truthfully, Judge, I don't think it'll be too long, maybe 3, maybe 4 days, stretching it.
Agreed, Your Honor.
Okay. Okay, so here's the date I'm gonna throw out, and Myrna, you can correct me if I'm wrong on this. If we're going up, meaning earlier, I can look at March 17th. Myrna, tell me if I'm wrong on there. I don't see any specially set.
I think as long as the court doesn't celebrate St. Patrick's Day, we should be.
Well,
okay.
that's what everybody's gonna have to show up in green. What are you talking about?
That'll work.
I feel like I've used this date for something because yeah, it's not the first time I'm talking about St. Patrick's.
There are no special settings that day, Judge.
And Your Honor, we've got a 2019 case pending in Ector County set for trial March 20th.
Yeah, I think it's going to be pretty tough to go backwards. I think we're going to have to go forward because my dockets are really full. In fact, I just assume, Myrna, go to where we are on our regular settings, which is June. Because honestly, trying to schedule you all where I can say you're it, if anything before then is really messy because it's full. Everything is full. So we know our January date isn't going, right?
Actually, Judge, I think that because I had the conflict, and I think there's a chance that I mean, I have a lot going on in January, but I think that the trial that was going to make it to where it wouldn't work, it's potentially not going to settle, but we might be pushing that date back.
Well, see.
So from my perspective, it looks like January could work. Let me just go back and double check that.
Okay.
Because we had on this one, I'm sorry, January 20th, right, is our initial date.
Sorry, I got out of that page. Let me go back. See, I start messing with the calendar and then it's like I'm all over the place here. Okay. Yes, January 20th, I have you down for jury trial. Yeah.
Yeah, so I had a trial on January 23rd. And as I said, it's looking like that case is probably going to trial is going to be pushed back. So, I mean, from my perspective, the January 20th date it appears to be a good date for us at this point.
All right. So, Ms. Vasquez, Mr. Garcia, looks like we've got a January trial. That's good. Yeah, let's do it then.
That works, Your Honor.
Okay, let's do it because I am still I'm going to actually give you that June backup trial date in the event something happens and we're in a lot of trouble. But let me look at the 20th.
And Your Honor, if I may, just so I can start getting my ducks in a row here, are we especially set for the 20th?
That's where I'm headed, Mr. Garcia. That is where I'm headed. I want to make sure what is on the 20th. So I have another civil case, a 2019 civil case, but that one I know is in flux. Everything else is, when do we have this guy coming back? (12/6). Myrna, we need to add to 2019 DCV 2381. We need to add a final status conference on December 7th.
Okay.
At 10 a.m.
Yes, ma'am.
I have one specially set civil case on that date. And you all are older. There's been some movement there that I wonder if that other specially set case is really going to go.
Judge,
all right, Monday.
Just to let you know, their mediation deadline is December 6th, and they're already set for their final pretrial on December 7th. on that.
Oh, there it is. That's right. Okay, so we're already coming in on the 7th. Yeah, my thought is I'm hoping they're gonna come in on the 7th and tell me they've got it settled and if not, I think there's been a change of attorney there. I believe the attorney handling that case has left the firm, so I don't know if they're gonna do something on that. So let's specially set these folks for January 20th.
Yes, ma'am.
So let me go back to your case. The system is really slow and I need it to be really fast. Okay. So then you also have your mediation deadline. Had you already mediated? Yes, you already done everything. Yeah, it's not going to happen again. You're not trying again. Okay. Because you all are coming back on the 7th. Yeah, you might want to come back. Let's change their time for that final civil pretrial. Let's set them at 10:45. It's set for 10 o'clock right now because my other folks are going to be here at 10:30. If I might lose you guys at 10 o'clock and then be like, oh, wait a minute. So,
Okay.
all right. And we're going to get you a June backup date. Okay.
That works. Thank you, Judge.
Well,
Thank you, Your
thank you
Honor.
guys. Thank you very much. We'll see you on the 7th.
Thank you. May we be excused?
You may. Take care.
Thank you, Your Honor.
Who's next?
Bottom of page 3, Judge.
Mhm.
In cause number 2020 DCV 1232, Eileen Ramirez versus Melanie J. Lamas. Announcement of council, please.
Ismael Pease on behalf of plaintiff. Good morning, Your Honor.
Morning.
Good morning, Your Honor. Karina Garza de Luna, and I'm standing in for Gabriela Marquez on behalf of defendant.
Okay, give me 1 second because I probably opened like 5 million calendars here and I want to make sure I'm on the right one. All right. What do we have here? We have a settlement?
We're trying to get there.
Unfortunately.
This
Well, you
is the
have-
case. We had a hearing last week, remember, Judge?
Yeah.
And they had told my client that she would be receiving some of the things that we're requiring within 48 hours.
Mhm.
She still hasn't received that, so they've extended the time to 5 to 7 days, I guess. I honestly, Judge, I don't see the case really going to trial. It's just a matter of providing those documents to Ms. Marquez. I did try reaching her earlier, but I do know she's in trial.
Okay.
Yes, Your Honor, she's in trial and she asked me just to announce ready on her behalf on this
Okay.
case.
So we have our setting. It's December 9th. Docket calls on the 7th. I see there's, I guess, some motion for continuance. It's not set for hearing, but I don't want to shadow anything, but we'll hear it on the 7th. Not really there. I'll tell you that. I get it, but not
No,
there.
I'm very hopeful that we'll get all the information by then, Judge.
Me too, Mr. Peace. I am very hopeful too. So I'm
Good.
going to leave that right there. Just see it. That's it.
Absolutely, Judge.
And we'll see you. Yeah, maybe I hear from you sooner than the 7th.
I really
But
hope
if
you do.
not, yeah, me too. Me too. Because you all are up there on the list. Okay. So, Thank you very much.
Thank you, Your Honor.
Thank you, Your Honor. I'm also standing in for Miss Peyton Campus, but that one's set at 10:45.
Okay, so we're already at 11 o'clock.
On that one, Judge, it was our motion to compel, but we're gonna go ahead and pass it because we did receive everything we needed.
I think that was Mr. Riojas and he kept. There you
Yeah,
are.
I'm here, Judge.
I think you were logging in since yesterday. I thought I saw you yesterday on my criminal docket. You made me nervous.
I got nervous. I logged in a day early because I
know.
thought I was logging into another court. Then I realized I wasn't in your court and I was in another court. So yeah, I was
Well,
like, what am I
you
doing
know-
here? This doesn't.
And you can
Defendant
imagine what
and-
I'm thinking because, we're, some days we're criminals, some days. So as soon as I see one of your faces that are not in the right place, it's like, ugh.
Yeah, no,
So-
it'll be a long time before
Let's-
you
let's
see me in the
call that
criminal
one.
court.
Let's call that one really quick, please.
In cause number 2022 DCV 0577, Katie Jo Munoz versus Timothy Eugene Myers. Announcement of council, please.
Robert Riojas on behalf of the plaintiff.
And Karina Garcia Luna standing in for Peyton Campus on behalf of defendant.
Okay, and I have a set for a motion to compel off the record. I guess, do you all have an update?
Yes, Your Honor, we did receive everything that we were requesting, and so we would like to go ahead and pass that hearing.
Okay, so I don't have you coming back until, well, we also have an entry scheduling order. Did we get the scheduling order on this one? I feel like we did. Is that right?
I thought we had. If not, Your Honor, we can get it done and get it to you pronto.
I feel like I signed it, but Myrna, if you'll just confirm that we did receive it.
I don't have a record of it, Judge.
Let me see. I signed a few this morning. If not, if you already have it, please send it over so I can sign it over because that's what we're here for as well. And
Yes,
then I
ma'am.
won't see you all until final status conference in May.
It's a long time. It's an auto case, Judge. We're hopeful we can get it settled or mediated. It's not a complicated case.
What mediator are you all using?
I don't know if we've agreed. I usually am okay with Mitch Moss or Chris Anclift or Judge VA. Any of the local guys is fine with me.
Okay, so I need you all to agree to one that should be part of your scheduling order. If you want to go ahead and notate that on the scheduling order or the email, okay? When you turn it in, okay? You need
Yes, Judge.
hearings outside of those dates, let me know and we'll get you scheduled. Thank you.
Okay, thank you, Judge.
Take care.
That's all I have. May I be excused?
Absolutely. Take care, y'all. Bye-bye.
Thank you.
Who's next?
Up on page 4, Judge.
Mhm.
In cause number 2022 DCV 3018, Jaylene Hidalgo versus Victor Luevano et al. Announcement of council, please.
Good morning, Your Honor. Daniela Rabinotti for the plaintiff.
Good morning, Judge Blake Downey on behalf of Expressway Autos LLC, DBA Viva Ford.
Okay, well, good morning. Status conference. This is transferred recently. How are you all doing? Let's
Your
get us
Honor,
really
our
ordered.
answer, all right, we're great. Nice to see you. Our answer is not, defendant's answer is not due until Monday.
Okay.
But I just wanted to hang out in y'all's room for a little while.
Well, you're welcome to join us anytime you'd like, Mr. Downey. All right, so we're gonna do a scheduling status conference on December 14th at 10 a.m. Okay?
Sounds great.
Ándale pues.
Thank
all
you.
for showing
Thank
up.
you, Judge. Have a good one.
Take
You
care.
guys
Bye,
too.
Mr. Downey.
Bye, Daniela. We'll see you.
Take care.
All right, who's next?
Middle of page 5, Judge.
Mhm.
In cause number 2022 DCV 0266, Sun State Equipment Company LLC versus LMJ Construction Company LLC. Announcement of council, please.
I think you might have just called my case. I'm so sorry. Was it DCV 0266?
Yes, ma'am.
Okay, I'm sorry, Your Honor. I'm here on behalf of Sun State Equipment Company.
Okay, and do we have have we had any communications from LMJ Construction Company? No?
I don't believe so, Your Honor. There's nothing filed in the case. There's been no answer, any.
Have you all had any contact with them?
I don't believe so, Your Honor. I don't have that information in front of me, but
The motion for default was filed on September 26th, so we're over 30 days here. Order setting hearing 9/28, notice of hearing went out on the 30th. So did we receive anything back? How was notice sent? Is it Miss Stickney?
Yes, Stickney. It was sent via regular mail and certified mail.
Did we receive something back on that certified mail?
The copy that I have, I can pull up the number. I was gonna say the copy I have is not the scanned copy with like the.
You know, okay, emotional, let me look at that and then the order. Have we looked to see if there's anyone present, Mr. Marufo? Because both the order setting hearing and the notice indicate that the hearing is happening at the courtroom, right?
I will check, Judge.
Yeah, there hasn't been any of that kind. Was there any kind of notice regarding the manner of the hearing, the manner in which the hearing would be conducted, Ms. Stickney? Because I know our order setting does not include, let me see.
Our notice and our cover letter don't indicate that they're.
Okay.
That it was virtual.
Yeah, let's go ahead and I just want to make sure we have this kind of covered. Okay. Let's have this reset. Let's see, we're on the 9th for the 14th as well at 11 a.m. We need to indicate on the notice that the hearing will be held remotely. And if we can include the login, Myrna, I don't know if we can have that order setting hearing include the login information. And then at that time, Ms. Stickney, at least I'll feel comfortable saying we gave them notice of the remote proceeding. It also has the information for the court. So in the event they couldn't, log on remotely for whatever reason, their presence here also, we'll take that too, because we can set them up on Zoom in the courtroom. But at least that way, there's no complaint that they didn't know that things happen on Zoom.
Yes, Your Honor. By the 14th, do you mean December 14th?
Yeah, December 14th. It's just outside of 30 days. So the sooner you can, Myrna, get that notice over to them or the order setting hearing, then Ms. Stickney can get the notice out as well. Mr. Marufo, was someone there?
No, Judge, nobody was in the waiting area outside the court.
Okay. And it was set, yeah, it's at 11, it's 11:15. So I just want to make sure we cover our bases. It's about 30 days out. We'll handle it that way, okay?
All right, and that one is also at 11 a.m.?
Yes, ma'am.
Okay, all right. Thank you, Your Honor. May be excused.
You may. Thank you.
Thank you.
Who's next?
Staying on page 5, Judge. In cause number 2022 DCV 0314, Ramon Carrion versus Von Finwell's Elite German Shepherds and Cindy Jimenez. Announcement of council, please.
Good morning, Your Honor. Daniel Marquez on behalf of Mr. Carrion, plaintiff.
Okay. Where is Miss, have we called Miss Hemans? Okay, well, let's get in touch with Miss Hemans, see where she is.